Good afternoon and welcome to the first of the Dean Speaker Series and Diversity Week. We will just give one more minute for all of our participants to enter the webinar. All right, I'd like to get started. So good afternoon, all. Welcome again. For those who may not know, my name is Shalak Richards. I am Assistant Dean of Student Life, Diversity, and Belonging, and it is my pleasure to welcome all of you to today's Dean Speaker Series and the kickoff of Diversity Week. I am so pleased that today we are able to join the speaker series graciously with Dean Karen and Diversity Week to start this important conversation. Professor Brown is one that we are so pleased to have, and Dean Karen will introduce her more. I'd like to remind everyone that Diversity Week will continue with an interfaith panel tomorrow, open conversation on Wednesday, a partnership with the California Law Organization, who's presenting Black Lives Matter and the US Constitution on Thursday, and then closing with Diversity on the Bench and a conversation with LA judge and as well federal law clerks. We believe this is going to be an exciting, interesting, and a week that will spur much dialogue across the law school. I'd like to also share that this is also the kickoff of our Race in the Law series. And so we will be continuing conversations surrounding Professor Brown's book that you will hear more about today throughout the semester. Please keep your eyes open for those emails. I will now turn over to Dean Karen.
Dorothy Brown is Asa Griggs Candler Professor of Law at Emory Law School. She's a nationally recognized scholar in tax policy and critical race theory and has published extensively on the racial implications of federal tax policy. Dorothy's book, Critical Race Theory, examines the racial implications of taxes, of cases covered in the first year curriculum. Her forthcoming book, to be released in March 2021, is The Whiteness of Wealth: How the Tax System Impoverishes Black Americans. Dorothy is a highly sought after speaker and frequently appears in major media outlets like the New York Times, Bloomberg, CNN, Forbes, and NPR. Before joining the faculty at Emory, Dorothy served on the faculty at George Mason, Cincinnati, and Washington and Lee law schools, where at each of those schools, she won teaching awards. Dorothy is a friend of Pepperdine Crusoe Law. She delivered the keynote address at the Critical Tax Theory Conference at Pepperdine in spring 2019, and was a Strauss Distinguished Visiting Professor at Pepperdine and taught federal income tax and tax policy. Please join me in welcoming Dorothy Brown.
Thank you, Dean Karen. Thank you for that lovely introduction, and thank you for reminding me of that picture. I did really enjoy my visit in the spring of 2019. So I'm also delighted to be here today to talk with you about my critical race theory casebook and to talk about the role of racism and systemic racism in American legal doctrine. And I want to start by talking about how is it I came to write a book about critical race theory in the first year curriculum to begin with. And it starts with me being at Cincinnati, which is where I met Dean Karen, and getting an offer to visit Washington and Lee Law School. Washington and Lee is in Lexington, Virginia. It is named after George Washington and Robert E. Lee, right? So the dean asks me if I would be interested in teaching a course in critical race theory. I was a little surprised. I was a little concerned. I wanted the visit to go well, and I wasn't sure how a seminar on race and the law in rural Virginia would go. So how I decided to approach it was to look at cases in the first year curriculum. So basically, anyone who had completed the first year, second year, third year would be able to take the course because the only prerequisite was taking the first year. Sounded like a great idea. I was going to get cases. I was going to talk about the cases. The problem was, of course, well, you don't know this. Paul knows this. I didn't teach in the first year. So this was a problem, but I had friends who did. So that particular summer, I basically hounded all of my friends who taught in the first year and asked them to give me cases that they thought systemic racism played a role in, which is what they did and which is what I did. So I had my own materials that I taught from. It was very well received. The visit obviously went well because I wound up with an offer and I ultimately accepted it. But thinking about critical race theory, and of course, the initial question should be, what is critical race theory, right? Critical race theory, or at least how I define critical race theory, is what role does race play in the decision? It's easy to answer once you have all the facts, but what you often find in cases that are edited in the casebook, you don't have all the facts. So one of the things I always do when I teach a specific case is ask my students to describe how the first time they encountered the case, how it was discussed. And I've taught this at Washington and Lee, I've taught it at Emory, I've taught it at UVA, I've taught this course at any number of law schools, and inevitably the students say, well, when we covered it the first time, we never talked about race. And you might ask, why is that? Well, people are often uncomfortable talking about race if they don't normally do it, right? So the faculty at the various schools I've been at or taught at are often uncomfortable leading conversations about race with a multiracial group of students. So it gets glossed over. The casebook author didn't put in the necessary facts. So one of the things I always say, if you want to talk about race in the classroom, the first thing you have to do is prepare the students for it, because they won't know this is going to happen if you don't prepare them for it. And a book that ignores the role of racism, ignores the race of the parties, a book that doesn't provide the students with that information would have no way of knowing they were expected to actually have a conversation about it. So one of the things my book does is it gives the background information that would allow the discussion to be thorough, to be probing. It would allow the students to have the discussion to begin with. So I put together different cases, different law review article excerpts. I'm in the 3rd edition of the casebook. I have committed to a 4th edition. I pushed them off until 2022 because my other book is coming out next year. And we'll see if 2022, if I actually make it or if I push it back further. But in the 3rd edition, I added or substituted the 2nd chapter on racial bias and the judiciary. And when you think about the first year curriculum, it's all about the common law. And I kind of had a duh moment as I was thinking about revising the from the 2nd edition to the 3rd edition. How come there's nothing about judging? Judges create the common law. How come? So I put together a chapter on racial bias in the judiciary, which is chapter 2. So I'll just go through the various chapters of the book. The first one is an introduction. It tells you a little bit about critical race theory, but it's not that complicated. It really is, what role does race or racism play in the decision-making process, in the case that you're reading, right? So the introduction gives different perspectives on that, but that's basically what the question is getting at. The second chapter, Racial Bias in the Judiciary, I have excerpts of different articles in there, and one of the article excerpts talks about whenever we have a Supreme Court justice whose confirmation hearings are going on, they often talk about their background, what city they grew up in. There are lots of diverse elements, but they don't often talk about race or the role that their race played in their being in front of the Senate, right? So we talk about, or the chapter talks about cases that will bring up a race of the parties, but not necessarily consistent. So why is it you may know the plaintiff's race, but you don't know the defendant's race? Or why is it you know this particular expert witness's race, like we do in the Ricci case, but we don't know that expert witness's race? If the judge puts it in the opinion, does it matter? Can you say it was an accident? Right, so all of these questions we get at in the second chapter. What role does the court play, does the judge play when they write their decision to tell the reader whether race mattered or whether it didn't? This is also an opportunity for me to talk to my students about who might want to be a judge one day and what kind of a judge would they be. So it's a necessary chapter. I'm glad that it's in there. I'm disappointed in myself that it took 3 editions to get there, but I did finally get there. The third chapter is torts. And I start the torts chapter with an O'Brien case. It's an Irish girl who is sailing to America, and there's a question about whether she was vaccinated before and whether she gave consent to be vaccinated again. And I like starting it with that case because you might think, well, critical race theory, it's all about people of color. Well, everyone has a race. White teenagers from Ireland have a race, right? And what you find out when you understand the history of race in America is all white Americans are not treated the same, and all white Americans were not even conceived of as white. So there's a famous book, How the Irish Became White, right? So that suggests when the Irish immigrants came to the United States, they were not treated as white Americans. So I want to expand the students' thinking on race to realize that everyone has a race. And while we might think of Irish Americans today as white, and they are white, historically, America did not always think of Irish immigrants as white Americans. So we start there. We move to a couple of other cases, one of which was written by Judge Posner, and it's Wassel v. Adams. And Wassel v. Adams is a case that looks at the liability of a motel owner for an assault that took place with one of their guests. And the person who made the assault, in Judge Posner's words, was a respectably dressed Black man. There's nothing else in the case about race except the assailant who was never caught. So we talk about, well, why do we have that information? What is Judge Posner trying to convey to us about who's liable, why the victim is 97% liable, which is what the court held. And we talk about the fact that it has to be relevant or it wouldn't be in the opinion. So now I'm going to do a digression. So I taught my book at UVA, and UVA has a lot of law and economics faculty members, and a lot of first-year courses are taught from a law and economic perspective. And Judge Posner is revered. Judge Posner is someone that is looked up to. People describe his opinions as first rate, as, you know, a model, as just eloquent. When you think about a judge, Judge Posner comes to mind. So needless to say, I was walking into a buzzsaw, right? So we get to the opinion, and it's the article excerpt after the opinion where the author, the legal scholar who I excerpt, really goes after Judge Posner, like mercilessly. And the students who have been trained to revere Judge Posner are pushing back. Well, he didn't mean it. It was a throwaway line. I'm sure it just was a, you know, not a typo, but close to a typo. So I found myself, you know, hiding my laughter, because this is a judge who doesn't make mistakes. This is a judge who's eloquent. This is a judge who says what he means. This is a judge who's brilliant. And I have students who are complaining, or not complaining, but defending this brilliant jurist by saying, well, he just didn't mean it. He didn't pay attention to those words. And it's, of course, not true. Of course, he meant it. Of course, it meant something. And we spend time, you know, we spend time talking about, he meant it. How do we square that with the opinion, right? And one of the takeaways I always make is, if race is relevant, and I tend to think it's relevant more often than not, I want to see all the racial information, not just the respectably dressed Black man who's an assailant. I want to know the race of the victim. I want to know the race of the motel owners, right? So we have a better discussion when you have all of that information. And the torch chapter ends with the Fisher case, which is a case about a Black man in Texas who goes to lunch with his colleagues at a country club, and a server comes up to him. He's in the line at the buffet. He takes the plate. He's about to put food on his plate. A server who works there snatches the plate from him and says, "We don't serve Negroes here." And he's embarrassed and he sues. And at the lower court level, the court applies the Texas Criminal Penal Code to say this isn't a criminal violation, and therefore he loses, even though, and this is in the 60s, even though the jury awards him $900. So you have to ask yourself, Black man in Texas in the 60s gets $900. Oh my gosh, what happened, right? You wouldn't necessarily expect the jury to go that way. Well, it goes up on appeal, and the appellate court actually applies the right law. It's tort. It wasn't criminal law. It's tort law. And it was, of course, a battery, because he touched the plate, which touched him. This is, you know, battery 101. But the appellate court does something very interesting. They personalize the Black victim. He is a mathematician who works for NASA. Okay, so the court, I argued, played a little bit of respectability politics. Here's this Black man at NASA who is working on government projects, really important government things. And how could we treat him this way? So yes, he should win. It was a battery and he should get $900. So the case is interesting because my students are looking for kind of like a win. They're looking for a good opinion, and they get to Fisher and they go, this is a good opinion. Well, some of my students say that. Other of my students says, well, it shouldn't matter where he works. It shouldn't matter that he's a mathematician at NASA. Why do we care? His plate was snatched because he was a Negro. That's a battery. So we talk about what a good critical race theory opinion might look like, right? One of the downsides, I would say, about being a crit or being a critical thinker is you literally criticize everything, right? And I think that leads to nihilism. And I don't adhere to that. So I'm always pushing my students, okay, this is bad. How would you do it better? This is bad. How would you do it better? Right? So we talk about, yes, that's, we're glad the judge found, based on the law, that he is eligible for $900. And it was a smart attorney that sued for battery and not injunctive relief or anything that would not have put money in his pocket. Battery allowed for money in his pocket. Intentional infliction of emotional distress did not, because there was no physical injury. So his lawyer picked the right cause of action and an appellate court upheld him. But I want to come back to what would a good opinion look like when I move on to contracts. So the third chapter is about contracts. And most people who have had contracts have had the Williams v. Walker Thomas Furniture Company case, right? So, and that's one of the cases that we talk about in the contracts chapter. And it's about Oralee Williams, who bought a stereo that the case tells us was $514.29, if I remember correctly, and failed to make a payment, and the furniture company repossessed the radio and everything else she had ever bought from them. Because the way their collateral clause operated was you bought on credit, and until you paid off everything, you owned nothing. So the issue before the judge was that an unconscionable contract? And the court talks about education level. The court talks about unequal bargaining power. The court talks about a lot of things, but you don't leave the opinion actually knowing when the unconscionability doctrine is going to be used the next time. The judge wrote the opinion very sympathetic to Oralee Williams. But what I find interesting, and the article excerpts that I use afterwards talk about this as well, is it really education level? Well, first of all, we're never told what Oralee Williams' education level is. So if it's about education, wouldn't that matter? Well, one of the articles that I excerpt teaches Williams v. Walker the following way. The day before the case is to be discussed, they hand out that collateral clause to the class, and they have the students, they call on students to explain what it means. And it usually takes 4 or 5 students to do it. Now let's review. First year law students are college graduates, and they can't figure it out. So is it really about education? What level of education? No, it's really not about education level, because people who are highly educated can't understand what that clause means. But there was a lot of emphasis in the opinion on Oralee Williams. She had 7 children, and the opinion is written in a way that causes the students to judge her. So one of the obvious comments students make is, what is she doing buying an expensive stereo when she's got all those kids? That doesn't make any sense. Oh, by the way, you find out in the majority, they talk about a social worker. In the dissent, you find out she's on relief, she's on welfare, right? So suddenly, oh, and we're not given her race, but everyone assumes she's Black. And when I say everyone, the students assume she's Black. I've had Black law professors who assume she's Black, but it's been researched and she is in fact Black. But you don't assume it, you actually have to find out. So one of my colleagues actually knew someone, Blake Morant, who I think is going to be the Strauss Distinguished Visitor in this coming spring, was the person who I cite in the book for finding out that in fact Oralee Williams was African American. He talked to one of the lawyers who represented her. Okay. But when you think about this unconscionable contract and the judge saved Oralee from this contract, you have in front of the students a poor Black woman who needs saving. What does this cause our students to think about Black women generally, perhaps Black women sitting next to them, if we ever get back to face again? What is it that this signifies, and is that a good way to have handled this case? Was it about education level? Was it really about unequal bargaining power? How would you, and I explore with the students, how would you rewrite this opinion from a critical race theory perspective? So we spend a lot of time beating up on the opinion, even though students are torn because they think, well, some students think she should get out from under this contract. Other students think, well, she signed the contract, she should be bound by it. Well, when you look at some additional facts, here's what you find out. Walker Thomas would not take cash for anything they sold. What store doesn't take cash for anything they sell? A store that wants to exploit the people that walk through their doors. They don't walk through their doors. The salespeople come to the customers in their houses and get them to sign a contract that's virtually incomprehensible. So what would a critical race theory-based opinion in Williams v. Walker Thomas look like? It would spend all of its time on the unfair business practices of the furniture company. It would show that Oralee Williams every month for years paid her bills. She wasn't a spendthrift. She didn't just throw money away. She paid every month $1,400 of an $1,800 debt. So you would find, in a way, Oralee is a hero. She managed to do all of that. You would also find that $500 for a stereo in the 1960s was probably overpriced. Any store that won't let you pay cash, she bought curtains, she bought any number of things on credit because they would not take cash, is likely not to be fair when they set prices. So a critical race theory decision would look at the furniture company and how they were exploiting the unfair bargaining power between the parties. So we talk about that in contracts, and then we go to criminal procedure, followed by criminal law. And all of the other chapters that I put together, I had to struggle to make sure there was enough in the chapter for a good, solid chapter. Not the case with criminal procedure and criminal law. In those two chapters, the question was, how on earth am I going to limit this to 2 chapters worth, right? There are books that are written. So in the criminal procedure chapter, I talk about driving while Black and the Wren decision, which basically has the Supreme Court saying if you make a traffic violation and a police officer sees you, they can pull you over, even if it's against police practices. Because in that case, they were undercover police officers, and the DC manual said you don't pull people over when you're undercover, but they pulled them over, found drugs, and the rest is history. Well, think about it. You're in California, you probably drive everywhere. How many times do you drive perfectly? You don't, none of us do. Well, except maybe Dean Caron, he might drive perfectly, but I digress. So other than Dean Caron, we don't drive perfectly, which means we can be pulled over at any time, but we're not pulled over. In fact, if all the police did was enforce traffic violations on the road, nothing else would get investigated, right? So the Supreme Court doctrine basically enabled those of us who are Black and Latinx to have targets on our backs and to get pulled over the minute we change a lane without a signal. So what you see in the criminal procedure, as well as we looked at prosecutorial discretion, right? What can be charged, what can be pled. So the criminal procedure chapter, I talked about prosecutorial discretion, but I limited to driving while Black, and that was enough to put the chapter together. Criminal law, I talked about the law of self-defense and who has the right to self-defense based on a jury verdict, right? Based on what the prosecutor would charge, based on what plea they'd accept, and the role of race in creating fear on the part of white Americans. So I look at that a lot in criminal law and sentencing. And as someone who doesn't teach crim pro or crim law, it was one of my Washington and Lee colleagues who told me I needed to separate those two out and to have a separate chapter on procedure and a separate chapter on criminal law, and he was absolutely right, in order to do either topic justice. So I will say, as an aside, I had my own materials, but then once I joined the W&L faculty, I asked again my colleagues who taught in the first year, what would they suggest? And I got more input as well. And then chapter 7 is the property chapter. And the property chapter is fascinating on a number of different levels. It focuses on how the law stripped property from Indigenous Americans, right? So there's this doctrine of discovery, which allowed the federal government to take land away from American Indians. And the last time I'm teaching it now, but the last time I taught it in face-to-face, I had one of my students put his wallet on the desk, and I walked over and took his wallet. And I said, I've now discovered your wallet. So how much is in it? It's mine, right? So we talk about the doctrine of discovery and how can you discover something that's already there, right? So, I don't think it's any more clear the role that systemic racism plays in creating legal doctrine than it is in property. I think it's clear in all of these cases, but the American Indian cases, the Indigenous American cases are breathtaking in the scope of the doctrine of discovery, but breathtaking also in how the opinions were written. I mean, the racism is blatant. They are called savages. They are denigrated for thinking of property differently than the American capitalist mindset. So the opinions there do all the work you need to do. And by the time we're in chapter 7, the students are experts at this point. But even if you weren't, you will see these cases they're just horrible in terms of, this is a case, a judge wrote this is the law today. We built on these concepts that have very racist underpinnings. So property kind of teaches itself as well. And then I end with civil procedure. And to me, I've always asked myself, is civil procedure the end or the beginning? Because if you can't get to court to get your rights heard, you don't have any rights. So civil procedure is the doctrine that allows you to get to court. And one of my former colleagues always said, civil procedure is everything. And she's not wrong, because if you have rights, you need to get them enforced. You have to go to court. And what does a complaint require? So that's what I look at, right? Because if you can get your case dismissed on the complaint, it's over. And there's been a tightening of what you need in a complaint. So we talk about how today it's so much harder to plead race discrimination in employment or any number of other instances than it used to be. So civil procedure, you think of civil procedure like you might think of tax, kind of dry, although Dean Karen and I would say, no, very interesting, right? One of the excerpts I have in the book is from Dean Kevin Johnson, who's the dean at UC Davis, and he talks about how to incorporate social justice issues in civil procedure in a way that brings the subject matter to life. Just like I find when I talk about systemic racism in my tax courses, the students get really interested. So, I find, as I wrap up, I think critical race theory, the role of systemic racism in creating legal doctrine is more important now than it's ever been. The summer of 2020 has really opened up people's eyes to systemic racism in policing and has caused them to ask the question in just about every area, including tax. So for example, this summer, for the first time, I think in forever, I've been talking to reporters about systemic racism in tax. I've been publishing articles in book chapters since 1996, okay? But suddenly, the summer of 2020, people realize systemic racism is everywhere, and let's look and see what we can do to make things better. So I'm gonna end it there and look forward to your questions and comments.
Thanks, Professor Brown. As Dean, I get to ask the first question. And after we scheduled this, critical race theory certainly has been in the news in ways it has not been in the news before, right? I assume folks have seen President Trump on September 4th announced that he was banning all training in the federal government having to do with critical race theory. And just an hour ago, the National Law Journal talked about this issue, and all 5 of the University of California Law School deans sent a letter opposing what the president has done. So I thought I would just ask you, how does it feel to have critical race theory now debated in the context of our national politics and a presidential campaign?
So first, I haven't seen critical race theory debated. I've seen the president and OMB condemn it, right, which isn't a debate. I've seen the dean's letter in defense of critical race theory, but it reminded me of the last time this happened. So it was the spring of 2012, and I wound up on CNN being interviewed by Soledad O'Brien because of it. That's why I remember. The spring of 2012, I was visiting at Georgetown, and Barack Obama was up for re-election, and the right found a video of him as a Harvard student speaking in defense of Derek Bell, the late Derek Bell. So Derek Bell was one of the founders of critical race theory. And in fact, the second edition to my casebook, Derek Bell wrote the foreword. He was profoundly impressed with what I had done in terms of looking at the role of critical race theory in the common law, but I digress. So they found this video of President Obama speaking in defense of Derek Bell, and they tried to make a big deal of it. So they tried to say critical race theory was racist and blah, 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 blah. So Soledad O'Brien had me on the show. Why? Because I wrote the book. As she introduced me, she goes, and here's Dorothy Brown. She wrote the book. And it didn't stop, right? So after I came on the show, talked about what critical race theory was, I wound up, somebody called, I was on visiting at Georgetown, but I was at Emory. Somebody called the Emory president and said, you have to fire her because of what she said on the CNN show. And of course, they don't understand how tenure works, but I digress. So I've seen this before, and I actually expected it. And the reason I expected it was I've noticed a lot of reporters and a lot of their guests talking about white supremacy and talking about systemic racism in a way I have never seen in my life. So I hear this and I'm like, oh, that's impressive. And I said, well, the backlash is coming. The backlash is coming. So when I saw that, the OMB, what I did was I downloaded it in case it disappeared from the website, because this is going in the 4th edition of the casebook. Because what struck me was how the OMB letter said anti-racism and critical race theory was un-American. And one of the things that critical race theory, one of the tenets of critical race theory is racism is baked into America. So here you have anti-racist training or critical race theory training, and they're saying talking about anti-racism is un-American, which kind of proves critical race theory's value. So I actually found it hilarious that I was so grateful they put it in writing because now it can go in the book. But I also believe most of the people who say critical race theory have no idea what they're talking about. They don't know what the theory is. They don't know what it means. They just say things like un-American, racist, blah, blah, blah. So I'm not surprised because there's been an awful lot of talk about white supremacy, about systemic racism, and there's been more white support for anti-racism than has ever happened before. So I'm not surprised at all.
Thank you, Professor Brown. It's my pleasure to be able to field some of the audience questions for the time we have left. And so one from one of our professors is, could you situate critical race theory within the broader critical legal studies movement? And I remember that in the first chapter, I guess sort of the introduction of the book, you do this a little bit, but can you expand on that and whether or not they are completely separate or whether they're situated within the movement?
So critical race theory was created because critical legal studies ignored racism. It was all about class. And if you know anything about American history, it's never just been about class. It's always been, why did we have enslaved people who were Black and not white? It's never been, racism always has explanatory power. So critical legal studies is kind of out of critical legal studies, critical race theory was born because the critical race theorists at the beginning did not see critical legal studies addressing issues they cared about greatly. So out of critical legal studies, critical race theory was born. So it's a critical theory, it's critiquing the existing system, but it's not a class, it's race, it's class, it's gender, it's intersectionality, but it's always race at the core. It could be race but it's gotta be race at the core.
I was going to say it's Kimberly Crenshaw Williams's definition, right? It's the intersectionality of it all that comes into play, and that I think makes it so interesting and ever evolving and part of the landscape. Well, another question we have, and this is actually from one of our 1Ls, is what do you think the future is for critical race theory's impact on legislation?
I actually am optimistic. And I'm optimistic, certainly in my field of tax law, because this summer, June of 2020, Senator Sherrod Brown from Ohio, in questioning the IRS commissioner, in his opening remarks said, we haven't thought about systemic racism in tax before, and we need to, and asked the IRS commissioner, what about systemic racism in the administration of tax law? So I see this field becoming more relevant. I see systemic racism playing a role in just about any area of law you can think, and I think there's an appetite and an interest for it. It's understanding how we got to this point. So I think the future is bright. I don't think it'll be easy because we have backlash, right? But I think the future is brighter than it's been in a while.
Very interesting. Well, I'm going to come back to that in a moment, but there's a question here that's teased perfectly on your tax comment. And I have to be the first to say that I waived tax in law school. So
I'm not mad at you.
But it's so interesting now to see you and Dean Karen care so much about it. I almost regret that. But I see, yes, I'm coming around to it. But one of our 2Ls said that they're very interested in your next book on race and income tax that I believe comes out in the spring. Yes. And would like to know more about how the wealth gap, particularly relating to tax incentives and in the time of COVID, affects Black people. Do you think the wealthy have been insulated from COVID due to tax incentives?
So I think, COVID has certainly been proven to have a racially disparate impact. And it isn't just a function of, access to healthcare. It's pre-existing conditions that impact Black Americans because we live in an anti-Black society. So it's more, it's high blood pressure because you go to work and your colleagues make you nuts with the racism that they engage in, right? So, I think, so that's a big question. I think that tax policy has a significant role in exacerbating and maintaining the racial wealth gap, which is what my book, The Whiteness of Wealth, gets into. You just take, for example, how wealth gets transmitted from one generation to the next. I'll just give you one statistic. Black college graduates are more likely to send money to their parents, and white college graduates are more likely to receive money from their parents. The money that Black college grads send to their parents goes to necessity. It's not going to help their parents build wealth. Whereas the money that comes from white parents of white college graduates are going to buy homes, going to pay down their student loans, going to build wealth. So that's just, and gifts are tax-free. So the wealth building gifts are received without any income tax consequences. So that's just one example of how tax policy plays a significant role in exacerbating the racial wealth gap. And research on the health side shows even when you get middle income Black and Latinx household Americans, they have disparate health outcomes from their white middle class peers, even though they have access to health care. So it's a function of doctors that don't believe Black Americans when they say they're in pain. I always go back to Serena Williams. She's having a baby, and we can just put aside the astronomical disparity in maternal deaths, Black women dying when they have children. But she's prone to blood clots, and she felt one, and she told the nurse, I think I'm having one, and the nurse ignored her, and she had to be persistent and go again and again and again before, and she was right, and she could have died. And Serena Williams, has so much wealth. It isn't about wealth when we're dealing with Black women in this instance who are not being believed by the medical community. And there's research about how some doctors believe Black Americans can absorb pain more easily than white Americans. So it's COVID-19 is bringing up the role that how wealth doesn't protect Black Americans the way it does white Americans.
I mean, something so interesting even in that is the talk of a vaccine. And I've heard so many Black Americans express skepticism, right, over this. And I think it was last week where there was discussion about a vaccine going to HBCUs. And
Yes.
Immediately that sort of brought up the Tuskegee experiment and Henrietta Lacks and this sort of generational trauma, right, in response to that. And I certainly don't want to go down that road in the 10-ish minutes that we have left.
No, let's not.
But it certainly it explains, and I think one of the things your book does so well is that it explains the underpinnings of all of this, right? It explains how this can be more than a through line for all of the ways the law impacts our daily lives, that the racism is baked right into that, and the consciousness that we have to employ. So that leads to a question I had for you actually, which is in the beginning of the book, you speak of skepticism that many have due to it being the 21st century. And of course, this edition of the book was published after the election and re-election, right, of President Obama. And so the skepticism that so many have about still living in a racist society. And I'm curious as to how you see that maybe answered with COVID and the societal unrest that's happened this summer, but also how you would address that moving forward as well.
So one thing I'll say with respect to the last point is history is so important. We didn't get to 2020 out of nowhere, out of Zeus's head, right? We didn't get here. We got here because of connect the dots. So one of the things critical race theory does is it brings the reality of history into this. So when I think about the Black Lives Matter movement and how they have moved the needle on systemic racism beyond just the police, I am cautiously optimistic. And I have poll numbers that show the movement of white Americans in believing racism is a problem in a way they didn't a year ago, just a year ago. So, and here's the sad part, there are no shortage of videos since George Floyd's murder of other police killing or maiming other unarmed Black Americans. So, you know, you would have thought, if you had told me, and I think this is in the book, if you had told me that the summer of 2020, we would be talking about defund the police in a serious, thoughtful way, I would have laughed at you. But when you see what happens time after time after time, and there's nothing that seems to be able to stop it, people start thinking about, well, let's try something else. So, you know, I think the videos matter. But I think COVID-19 has played a role, and not on the health side, but in the side of people being able to sit at home and work at home and watch TV. More people saw the George Floyd video than would have seen without COVID-19. They'd have been at work, they would have been busy, it wouldn't have made the dent that it did. So I think we have a perfect storm in terms of people working from home, people with cameras, people who have been demonstrating since May. It hasn't stopped. The media may have stopped covering it, but it hasn't really stopped. So, you know, I'm optimistic that people are fed up and want to change things.
Thank you. We have several more questions, which leads me to believe that while this is part of the Dean Speaker series, we will have to have you back as part of the Race and the Law series, perhaps in the spring, to speak specifically on tax in your new book. But a question here from one of our 2 owls is, what are the most harmful misconceptions about critical race theory you have heard? And what are thoughts you would give to correct those inaccurate characterizations?
Yes, I think the notion that critical race theory is about insulting and beating up on white Americans, right? So in the history of America has shown Black Americans, Asian Americans, Latinx Americans, Indigenous Americans have received awful treatment at the hands of white Americans. That's just the reality, right? So it's not saying all white people are awful. It's saying this is the history and this is what we need to take account of if we are going to move past it. So to me, the most harmful idea is critical race theory basically is about treating white Americans really badly when it really isn't. It's showing how power has been implemented in a way to disadvantage people of color and advantage white Americans. So the notion that it's about white bashing, one, isn't true, and two, you have to think about history. You can't say we're done with slavery, so we shouldn't talk about it, when there is a straight line between slavery, slave patrols, and mass incarceration. You can't just ignore history. So it does require white Americans to come to terms with things their ancestors have done, or if their ancestors didn't have anything to do with it, things they have benefited from nonetheless, simply because they're white in America.
Thank you. And I guess this may be our final question. This is from, I believe, even one of our library staff, a brilliant woman herself, who says, Professor Brown, for the first time in my life, it seems that reparations for general harms caused by slavery are being discussed seriously, particularly by major party political candidates. Do you see opportunities in tax and education policy for addressing some of these harms?
So, reparations is interesting, right? So we had a hearing, I think it was last summer, and we haven't heard much else. I do believe at the end of the day, you're not going to fix the wealth gap or any number of other gaps without some kind of reparations. But that said, what it looks like, so my thinking is no matter what reparations looks like, if the system itself isn't fixed, the reparations won't help it. So I believe you have to root out the systemic racism first before you can then have reparations fix things. Because I think you'd be doing is throwing good money after bad. So I think you have to deal with the system for building wealth that enables one group to benefit and another group to be depleted.
Well, I would just ask, as I mentioned earlier, we have this series coming up, and so excited this semester we are going to be talking about criminal law, property law, and civil procedure. So 3 of the chapters in your book. And I'm curious, what would you hope that we take out of that as law students, as faculty, as staff, as even it's going to be open to our alumni? What do you hope we take from that?
That you can reimagine a different criminal law, a different property law, a different civil procedure rules, and work on that transformation. So we teach the law as it is, but we should think about the law as it could be and the role that lawyers have in producing that change.
Thank you. Thank you so much, Professor Brown, for your time. I'd like to remind everyone before we go that this is only the first of our Dean Speaker series, and thank you, Professor Brown, for kicking that off so ably. Professor Robert George from Princeton is going to be with us on October 19th in conversation with Dean Karen, speaking on campus illiberalism and the future of higher education. And that promises to be, just as this, a riveting discussion. So please, students, faculty, staff, friends of this school, mark that date and you'll see information on how to register for that coming up soon. Thank you again for your time, Professor Brown. Thank you, Dean Karen, and everybody participating. We wish you all well. Have a wonderful day.
Thank you.